So these are the three pillars. These are the three very broadly things that you need to focus on in law school. You master the law, you master issue spotting, and you need to master your professor. I'm going to go through each of these in turn. Mastering the law, what does that mean and how do you do it? Mastering the law is memorizing the elements and factors of the relevant claims for that area of law: criminal law, contract law, property law. I gave you an example in terms of battery. It's, you know, you'll have a case like the famous eggshell skull case in torts, or the hairy hand case. All of those are usually there to illustrate or illuminate one of the elements of a claim, or to set out the elements of a claim. This is kind of distinguishing the wheat from the chaff. They can be found in the cases, but don't mistake legal knowledge for the cases themselves. The cases are important, but not on their own. There's a way to use the cases, and I'll kind of get into this a bit more. So how in the world do you kind of master the law without kind of reading and rereading and rereading the cases, as the professors will tell you to do? And with the implication being you will learn the law this way. Your strategy, the thing that you do that other students won't do, is to pre-study, or what I call pre-study or side study the law. You use commercial outlines. These are Emmanuel's or Gilbert's, and all they do is set out for the subject matter that you're studying all of the elements and factors of the claims relevant to an area of law. All the kind of claims for torts: intentional torts, negligence, strict liability. In contracts law, you'll get all of the elements and factors involving contract formation, contract breach, and damages, things like that. And they get more detailed. There are a couple reasons to do this. First, just because they are the foundation with which you will be able to perform a legal analysis, but you will surprisingly understand class and even your reading better if you master the law first, if you study and ideally get in your head. I wouldn't go so far as to say memorize. It wouldn't hurt, but if you study these outlines, you're in good shape. Here's the analogy I always use for mastering the law. Law school, the analogy is, if law school were a medical school, there are two ways you could study the circulatory system. You could just look at a map of the circulatory system. You can see the heart and the lungs and all the arteries and veins and capillaries. You go, okay, that's I see, that's a model of the circulatory system. Law school just throws you into the deep end by making you cut open a person with heart disease and to perform surgery on them just to understand the map of the circulatory system. To spend time going through cases, a lot of the times cases are picked not because a lot of them are foundational, but a lot of them are selected because they present difficult problems in the law, which means that they're not super clear, which means that they're not a good base to understand kind of what normal life looks like, or what a claim, just the bare bones of a claim, actually is. Master issue spotting. Okay, so let's assume that you've mastered the law, or enough of it to be able to identify and assess claims. Mastering issue spotting involves what's called IRAC. This is the mechanics of issue analysis and spotting. Now, you will hear of IRAC as if it's an actual helpful thing. I think it's a very general framework for doing legal analysis. What does IRAC mean? It's issue, rule, application, conclusion. It's usually the structure of any legal answer, but I see it as less of a guideline on how to answer as just a description of what happens to be in a cogent legal analysis. There's the identification of the issue, the identification of the applicable rule, which is to say something that sets out the elements of the claim that's relevant to what you're trying to think about, application, and conclusion. So you need to learn how to do that in order to do an analysis and then to do issue spotting. How do you get good at that? And my shorthand for this is to take a practice exam a day. I already said if there's one thing you take away from this free webinar, it's that the things that you're asked to do are not the things that you will be tested on. If you can only take two things away from this webinar, it's that and Tapiad. If you work on taking a practice exam or a hypo every day, it's easy to say every day. If you do it on some regular basis, even starting at the beginning of the semester, you will have a gigantic legal analysis muscle in your head and will be unstoppable. But not everyone believes me on this. I have students who did well who can be the pudding that is the proof of that. So you learn the IRAC. You learn IRAC. It's not. Let me take a step back. Why do you need to do this? Myelin sheath. Myelin sheath. We're going to talk about biology for 2 minutes. Legal analysis is a skill, and I would argue it's even a physical one. Most people who go through law school eventually learn how to perform a decent legal analysis. The question for purposes of you excelling in law school is, can you get up that learning curve faster than 90 to 95% of other students? How do you do that? You need to practice early, and you have to practice the correct way, but you have to practice. The myelin sheath is what's built up in your brain. It's actual insulation that as you practice any skill, a mental one or a physical one, at this late age, I've taken up surfing. I'm getting better. A lot of that is the myelin sheath kind of insulating the signals that are sent from neurons to my body to surf crappily as I do. This is just as much a physical skill, to learn how to read quickly, to assess claims. You need to practice daily to get better at this faster than everyone else. The practice does need to be deliberate. You need to get feedback on the exams, on the practice exams you're taking. Where do you go to do that? If you have a very nice professor, they might be willing to look at practice exams and give you comments. I've had students at least ask their professors to do this. Usually they're not that helpful. A lot of classes have teaching assistants that look at practice exams. I was a teaching assistant to my criminal law professor. I think I got the best grade in his class. And this was a lot of my job. I sat in class and looked like I knew what I was talking about, but most of what I did was actually mark up practice exams, which is how I started on this second kind of career. You can also try to trade exams with peers. And see, I may have some questions. I'm going to take them at the end, but I'll take them in the order that they're listed in the chat if you have questions. The third pillar is mastering your professor. And a lot of this is, I'm kind of suggesting that you ignore your professor's advice on how to study, but do study what they do in class. Don't necessarily do what they tell you to do, but kind of at a meta level, study what it is that they seem to like in class. Ignore their study advice. Look up, if you want, on my website, larrylala.com, I have an article called Rainbow Vomit. It's also appeared on Above the Law, and it's that they basically anyway. The full article is on Larry Lala. I don't want to say more on this, but in short, I don't think the short version of the Rainbow Vomit article is law professors do not know what is effective in terms of getting A's. They know, remember that exams are graded blind. The professor has no idea what your study methods are. They assume that the students who got A's were the ones who did what they said to do, but they have no way of knowing. I have a lot of law professor friends. Some of them I let them know that this is my side business. I have a law professor friend at Harvard Law School. He's generally validated my advice, but he feels this certainty that he knows what it is that causes students to do well, but he doesn't have data. Professors hate, let's take a step back. One of the things that makes me mad is come December or May, I very often am on Facebook and I'll see my law professor friends who have very nice professional careers. They have a lot of freedom. They get to kind of study things that they want to. So nothing makes me madder when I see them complain or talk shit about their students. But one of the things that they will universally say is, oh, life is so hard, I have to grade these exams. They barely want to grade the exams. Guaranteed, very few professors actually know what works and what doesn't what doesn't work. They are not an expert in what takes to do well on the study skills it takes to do well in the class. They are experts at what they like on exams, since they're the ones who are applying their preferences to exams. So in class, you want to focus on the language that they use, certain preferences that they have for vocabulary. My criminal law professor liked to use the phrase Leningrad drunk, which to him was the shorthand for the intoxication defense, that you were, just being buzzed is not enough to negate specific intent on crimes such as murder or arson or burglary. You have to know that you're doing this. But it's not enough to have had a couple of beers. What is the level of intoxication necessary? It's kind of being at the level of blackout drunk where you don't know what you're doing. In class, he told this long random story about how in the 60s he'd studied at Oxford before going to Harvard Law School and had visited what was then called Leningrad, and drinking an entire bottle of vodka and walking on the Nevsky Prospect on his hands and knees. He called that Leningrad drunk. The reason I say this is it wasn't just, everyone always laughed at this story, but you were expected. It wasn't just something that got you extra points. You were expected to say that a character in one of his fact patterns was Leningrad drunk, or analyze it as to whether or not someone was at that level of intoxication. If you use the phrase level of intoxication sufficient to negate specific intent, he would not have thought that you had paid attention in class. You had to use the word Leningrad drunk. So a lot of mastering your professor so that you can maximize the chance that your good legal analysis appeals to your law professor is to focus on language, on preferences, and on hypos that they raise in class. Now, when I said before that law school exams are a set of facts that you have never seen before, that was kind of a partial truth. Sometimes professors will take a case that you are studying and say, what if we change this fact? Or what if we change this fact by this degree? what's the right result then? Is the person still liable? Is the person still guilty? Your ears need to be, you need to be super alert for these kinds of things in class. I will hop back to mastering the law. The reason that reading mastering the law is helpful in class, and not just understanding cases, but if you already know what a case is about, you are freed up to really listen, actively listen carefully for these other things, including hypos, including a professor's language preferences. You never want to walk into class and not already understand what the point of a case is. So all of these three factors kind of interact. Mastering of the law is the foundation for being able to form a legal analysis. It also, mastering the law, helps with mastering your professor. It clears up RAM in your mind so that you can focus on these other more subtle things that honestly are the difference between a B+ and an A- or an A- and an A. The easy schematic is that you need, this isn't completely accurate or to scale, but this is, in my mind, how the three pillars work. You need to start with mastering the law. That your ability to issue spot is built on your ability to master the law. And unless you're already issue spotting at a good level, mastering professor isn't really of much use. But if you're at this level, you can then really talk to your professor and make the professor really feel heard and get the top grade in your class. So this is kind of, totally informal. If you're at this, if you've really reached this level, you're in A and A- territory. Even if you don't do this, if you're a competent, if you're really practiced at issue spotting, let's say you never go to class, which you should totally go to class, not just because you're told to, but so you can pick up these other subtleties. But even if you didn't do this, being an excellent, competent issue spotter will get you in the range to get decent grades, A-, B+. That may be enough to do what you want. It's not totally dominating law school, but you will be at the higher end of your class. If you just master the law without having done this, you're going to be in the middle of the pack, more or less, unless you're lucky. And you may be, but chances are not.
Thanks for tuning into the show. Please subscribe if you haven't done so already to be notified of new episodes as I release them. And feel free to reach out if you need anything at all as you move forward with your prep. I'm happy to help however I can. In the meantime, I wish you all the best and take care.